Okay, hi, welcome. I'm Kirsten Howe. I am the founder, the owner, and the managing attorney at Absolute Trust Counsel. We are an estate planning law firm in Walnut Creek, California. Probably a lot of you on this call or this live event already are familiar with us, but I just want to talk a little bit about us. We are a team of estate planning professionals, attorneys, paralegals, and various other support folk. I'm very proud of my team. They're absolutely fantastic, very smart, very efficient, and super friendly and helpful. So I encourage you to check us out. Our website is absolutetrustcounsel.com, and I'll talk a little bit more about that later. I want to start by saying this is my first Facebook Live event, so I'm probably going to screw some things up, especially with the technology, and I hope you can forgive me. And also, I'm a little bit nervous about it, but we're going to charge ahead. We're all kind of feeling very, I'm just going to say, freaked out with the coronavirus floating around there. Everybody has something different that they're freaked out about. Probably the economy is bothering everyone. Certainly the fear of getting sick or having a family member get sick or even, death. I mean, that's our reality now. We've got to think about those things. So we're all freaking out about something, probably lots of things. My goal today is to share some information, share some tools that I hope will, number one, calm you down a little bit, at least in a little corner of your life. I can't invent a vaccine for you. I can't get more face masks to you. I can't get you eggs from Safeway, which I can't even get for myself. But I'm hoping that I can at least provide a little bit of relief from some of the fear that you're feeling, and also to help you come up with an action plan. Some list of items that you're going to take care of, and you know what to do and you know where to go to do it. So that's my goal for today. Hope to get that done in about a half hour. I have to, because I'm a lawyer, I have to start with the legal stuff. I'm not here to give legal advice. I really can't give legal advice unless I am talking to you one-on-one and I understand your personal situation. So I'm not intending this to be legal advice, but I think it's very valuable information and it'll be helpful to you and to your family. So with that out of the way, we'll just get started. So the first thing I want to talk to you about is some tools, some things that you can do. I'm going to share information, things that you can do to actually get things done. I'm also going to share some other free resources about that and other things. And then I'm also going to talk about some planning that you can do in addition to the tools that I'm going to share with you. And finally, I'm going to open it up at the end for your questions. So I hope to have enough time to answer lots of questions. The first thing we're going to talk about is incapacity planning. Incapacity planning is a very important part of estate planning, and I think sometimes people don't pay enough attention to the incapacity part of estate planning. They tend to focus on estate planning as what happens to my stuff if I die. But incapacity planning is, in a lot of ways, even more important because incapacity planning affects you directly and it's very immediate. So if you don't have an incapacity plan in place, you become incapacitated and your family needs to be able to step in and help you. They're going to be very frustrated. They're not going to be able to help you. It's going to be very difficult for them. And the default in that situation, if you don't have a plan, is they're going to have to go to court and they're going to have to get a conservatorship in order to be able to help you. And that's a problem for a lot of reasons. It's very expensive and it takes a long time. But right now, it's a huge problem. Our courts are not open right now. So we can't rely on that as our fallback plan. We actually have to be proactive, and we have to do our own private plan. So what am I talking about when I say incapacity planning? Two things. The first is a power of attorney for legal and financial matters, and that probably pretty much like what it sounds like. It's you in writing nominating someone to handle things for you if you should become incapacitated, to handle your legal things, to handle your financial matters. So, for example, they would be able to access your checking account. They could write checks for you. They could make sure your mortgage gets paid, that your rent gets paid, that your homeowner's insurance gets paid. Make sure all these important things that you can't afford to miss will happen. They would also be able to help with your financial accounts. If you needed to move money out of an IRA to pay your mortgage because you run out of money, or you've lost your job, but you're incapacitated and you can't move money around, they could help with that. They can help with your non-financial accounts. We all have lots of non-financial legal relationships. Like you have a relationship with PG&E, and you, unfortunately, you have a relationship with Comcast. Comcast isn't going to talk to you about your account if you're not you. So you've got to give somebody the power of attorney in order to be able to talk to Comcast. And I know that sounds trivial, but until you've had to do something like that for somebody, you just don't appreciate how important that kind of thing is. So that's your power of attorney for legal and financial matters. The second incapacity planning tool that everybody needs, and I mean everybody, if you're over the age of 18, you need to have these things in place so that your family can help you, is an advanced healthcare directive. So in an advanced healthcare directive, you are naming somebody else to make medical decisions for you if you can't make those medical decisions for yourself. It's very important. If you don't have that, again, your family can go to court and get a conservatorship. And in the meantime, the doctors are going to do what they think is best for you. And they don't know you. Most of us don't really know our doctors very well, and our doctors certainly don't know us very well. So you're kind of leaving it up to somebody who really doesn't know anything about what you want. So that's why it's just really critical that we do this planning for ourselves. The other thing about the power of attorney for legal and financial matters is that you can grant it to somebody even if you aren't incapacitated. So the thing that I'm thinking of is, if you have elderly parents who they're fine, they can do things for themselves, but really they shouldn't right now. They should be staying at home. They should not be going out to go to the bank. They can give their power of attorney to somebody else, and that person can go to the bank. Somebody younger. Yeah, we know younger people get coronavirus too, but it's the older people who we really need to be most protective of. So just keep that in mind. Okay, so now I said I was going to share some tools with you. So I have a couple of do-it-yourself tools. And I'm an attorney, so I am almost never going to say doing it yourself is a good idea when it comes to legal work. It's usually a bad idea because I've seen some really terrible do-it-yourself work, and oftentimes people who do things themselves, they spend more money on attorney's fees cleaning up the mess afterwards than they would have if they would have just done it right the first time around. So I'm reluctant to give you a do-it-yourself tool, but I think these are unusual times, and some of you may be feeling just so freaked out that you've got to get something done. You don't want to wait. You don't want to make an appointment with an attorney. You just want to get it done. So number one, you can Google California statutory power of attorney, and it'll pull up a 2-page form for you. Unfortunately, I don't have one with me. You can see I'm not in my office. I'm in my home, just like you are probably. But it's a 2-page form, and you check the boxes and you sign it. And now you have given somebody your power of attorney. I have a couple of things to say about that. You can either sign it in front of a notary, or you can sign it in front of two witnesses. And we're explaining that to our clients now, and we've got a whole system for them to get their documents signed legally without ever leaving their homes. Some people would be fine with going to a UPS store and finding a notary there right now. Some people would be fine with having a notary come to their home. There are such notaries. But, really, if you want to shelter in place and keep your social distance, we're telling clients just call your next door neighbor and, have them come over. They can stand out on the front porch. They don't have to come inside. All they have to do is be able to see you sign that document, and they can be your witness. Witnesses need to be disinterested witnesses. So if you're naming your child to be your agent under a power of attorney, that child can't be one of the witnesses, right? I mean, that kind of makes sense. The other thing about having a witness sign is when they sign, they have to sign their name, and they also need to write a sentence that says, basically, I saw this person sign this document in front of me. The forms you can find on the internet don't have that. They are set up to be notarized, but you don't have to have a notary. You can do it with two witnesses. Okay, so you can do that do-it-yourself project, the power of attorney. The other do-it-yourself project, you can also Google California Advanced Healthcare Directive, and you'll get a form. Same thing, you print it out, you check the boxes, you fill in the blanks, and you sign it in front of two witnesses. It's exactly the same thing. You can do that yourself. It's not my first choice for you, but I understand. We are all feeling a lot of anxiety, and if getting that done is going to help you, then by all means, go ahead and do it. I have one more do-it-yourself project, and that is for parents of young children. Parents of young children, sometimes the hardest part of estate planning for them, and definitely the most important part of estate planning for them, is naming a guardian. If something happens to me, who's going to be the parent of my children? There's nothing you can do that's more important than that. And you need to name that person in writing yourself. What will happen if you don't is your friends or family members will go to the judge and say, I want to be named the guardian, and the judge won't know who to name. There's no guidance there. So the family could get into a big fight, and it might end up that the judge picks someone that you didn't pick or you would never have picked. So this is really important, and here's your do-it-yourself assignment. If you are the parent of a young child, you're going to sit down with a piece of paper, and you're just going to write this sentence. If a child of mine ever needs a guardian, I nominate this person. And you write the name, and then you sign it and you date it. And you don't need a notary. You don't need a witness. In my office, we always use notaries, but it's not legally required. All you need to do is make sure that the person you've nominated has a copy of that document, right? Because they're going to need to show that to the judge. Okay, so I gave you 3 do-it-yourself projects that you could do. I now want to share with you some other resources. So we have on our website, absolutetrustcounsel.com, there's a tab at the top called Free Resources. Isn't that just so convenient for you? So you click on Free Resources, and the bottom one of those free resources says incapacity planning. And we just spent about 10 minutes talking about incapacity planning. So if you click on that, it's going to take you to a page that's just full of all kinds of resources on that particular subject, incapacity planning. There are articles, there are videos, there are podcast episodes, all kinds of things. So I encourage you to go and check that out. Okay, now There are also lots of other free resources on our website. If you click on the free resources button, you'll see we have a newsletter that comes out once a quarter, and we mail that to all our clients. We have a blog, we have a podcast, all kinds of things. So just go there. I'm sure you will find something that's worth a few minutes of your time. We have guidebooks. What is a living trust? Just go and check it out. I invite you to make yourself at home on my website. It's always good to have more visitors to your website. Okay, now we have to talk about the hard part, which is we talked about planning for incapacity. We also have to talk about planning for death. And I know that nobody likes that. I know my clients don't like talking about it. It's uncomfortable. And I know that because of that, a lot of times we procrastinate and we feel as though that isn't particularly urgent, so we can put it off. I'm here to tell you now is not the time to procrastinate. That time is past. We can't do that anymore. This coronavirus is going to get worse before it gets better, and we're all going to know somebody who got sick. Most of us are going to know somebody who died. So just don't procrastinate. The reason that you are doing estate planning is for your family, for the people that you love. You are doing it to make it easier for them. You're also doing it, you want to express your own wishes. If you don't do an estate plan, the California Probate Code will do your estate plan for you. That's not a problem, except that it might not be what you want. If you don't do an estate plan, you don't have the opportunity to protect your family. A big motivating factor for a lot of my clients is protecting their family. So you might have children who are too young for an inheritance, or maybe they're not too young, but they're just not very mature and not very responsible. If your children inherit from you, then the minute they turn 18, that inheritance is theirs and they can do whatever they want unless you do the planning. And speaking from my own personal experience, I'm pretty sure 18 isn't the right age. So you want to take control of that. You can protect your heirs from creditors. You can protect them from people who don't have their best interests at heart. You can protect them from substance abuse. You can protect them from divorce. You can do all of those things by just doing your own planning. And finally, if you don't do your own planning, your family is going to end up in probate court. And for lots of reasons, that's a really bad default plan. It takes a long time. It's very expensive. And like I said, right now, the courts are closed and we don't know when they're going to be up and running again. And once they are up and running, there's going to be a huge backlog. So they're going to be even further behind than they already are. So don't rely on the courts as your plan B. Do a plan A, do your own planning. So what does that mean? When you meet with an attorney, most likely we're going to recommend, for most of our clients, we recommend that you do a trust. And you're also going to have a will. And it's in those two documents that you plan out what you want to happen after you pass away. We have lots of written information and guidebooks in our free resources tab about wills and trusts. I'm not going to take up your time talking much about those right now. You can go find that. But we can help you with this. We are here. We're working. We haven't stopped working. We're sending estate plans out to our clients with instructions of how to get them signed without ever having to leave their homes. We want you to shelter in place. We want you to observe social distancing. And so we're here to help. If you need help from us, you can call. Our phone number is 925-943-2740. You can always go to our website, which is, again, absolutetrustcounsel.com. We have a calendar feature. You can schedule a phone call, and either Emily or Danette will call you. They will inquire, ask you a bunch of questions and figure out what it is you need, and then they'll set up a phone call with me, and we'll do a 30-minute phone call or a Zoom meeting or whatever you want to do. and I'll figure out, together we'll figure out what you need and how we're going to go about doing it. And I can usually tell you how much it's going to cost. And so all you wasted is 30 minutes of your time. It's definitely worth doing. If you need our help, we're here for you. Now I'm going to open this up to questions. Now, bear with me. I might not be able to figure out where the questions are. I'm so sorry. See more. Okay. I told you I was going to do some goofy things here. Bear with me. I'm not seeing my questions. Okay. Will your loved ones? No. I'm not seeing questions. I'm so sorry. Does anybody have a question out there? Oh, here we go. Okay. Sorry, everyone. I'm a goofball. My first question that I've been able to find, my mom has dementia. Can you still help us with her planning? So the answer is, I'm an attorney, so this is my standard joke. The answer, of course, is it depends. We do help dementia people with dementia. We do help them with planning. It depends on their capability. If they're able to understand what we're doing, sometimes dementia in the earlier stages is just memory loss, and people don't have a lot of short-term memory. But if they're able to understand what they're doing, a lot of times we still can help them, and we do that quite a bit. So I hope that was helpful to Taylor. Thank you for your question. Okay, another question I have here. How long does estate planning take? Is it just a one-time process? Great question. Okay, how long does it take? Of course, it depends. But generally, in my practice, once we have met with you and planned everything out in a planning meeting where we're asking you a lot of questions and getting everything laid out the way you want, our typical work process takes about 2 weeks. We can accelerate that. We can expedite that if that's really important. The fastest I've ever done a complete estate plan from beginning to end was a gentleman came in at 9 in the morning, and then that was the first time I met him, and then he came back at 4 in the afternoon, and everything was ready, and he signed it and done. So we have that capability. It kind of depends on your situation. The other part of that question was, is it just a one-time process? The bulk of the planning is just that one time. We encourage our clients to keep everything up to date. So, your life changes, your family changes. You need to revisit your estate plan from time to time to make sure that things haven't changed. So a lot of our clients end up updating. And I would say probably it's not uncommon for people to update once or twice through their lives because things have changed. Okay, so that's a good question. I just got a question, how often should I update my estate planning? And thank you, Keely. She's my sister. The answer is, of course, it depends. So you want to update when something has changed. And I see my clients tend to fall into 3 groups. So we have clients who come in when they first start either acquiring assets or having children. One or both of those things is going to trigger them. So we have young clients who come in, started to have children, now they're going to set up an estate plan. Very, very often those clients will come back again when their kids are now young adults, because things have changed. Now they know who these kids are. They maybe feel as though they don't really need to have some third person be their successor trustee, they can have the kids involved in the estate plan. So very, very often we have people updating at that point. And then the next most common group of people that I see in my practice are people very much closer to the end of their life, people in their 70s or 80s. And oftentimes it's their adult children who say, you know, let's just make sure that this estate plan that's now 20 years old is still going to do what we want it to do. And the children will say, Mom and Dad, let's just go meet with your lawyer and make sure everything's up to date. So that's what I would say about that, updating. Okay, I already have a will. Do I need to do estate planning? Thank you, Ivy, for that question. I already have a will. It depends, you know, if all you have is a will, then yes, you need to do more. We spent about 10 or 15 minutes talking about incapacity planning and how important that is. And a will has nothing to do with incapacity. A will is a document that doesn't mean anything until after you die. So it's not going to help you with the things that you need to have help with while you're alive but incapacitated. So yeah, you need to do an incapacity plan. And if you only have a will, you might need to have a trust if what you want is to keep your family out of probate court, which I think most of us would like to. Okay, I got another question. And thanks for your questions, everyone. I really appreciate it. Someone recently asked me if they should name a married couple as a guardian for their children. What would you recommend? It's not terrible to name a married couple as the guardian for your children, but I generally try to recommend against it. And here's the reason. If something should happen between that married couple, if they divorce down the road and they are already both the guardians of your child, now there's a child custody and child visitation issue and all that kind of stuff, and your child's going to be in a divorce court even though their parents are dead. So I think it's better to pick one of the couple, either the husband or the wife, and name them as the first guardian and name the other one as an alternate, just in case something happens to the first one. I think that's a safer approach. Thank you for that. That was a good question. Let's see. Okay. Here's one. I hope I can answer. When I was in the emergency room last year, the staff told me I could complete forms that would give instructions on what I want to happen. So these forms I can get at the hospital. If so, what is the difference between the forms? Okay, so oftentimes when you go into the hospital, well, a lot of times you go in the hospital, you didn't expect to go into the hospital. You didn't plan. In this case, Geraldine is saying, I was in the emergency room. So that was an unplanned visit. So she wasn't carrying her estate plan around with her that day, I hope, I imagine. And the hospital staff will ask, do you have a healthcare directive? They really want you to have a healthcare directive. And they will, in a lot of situations, they will provide you the form. If you say, no, I don't have one, they'll maybe point you to it online, or they'll actually hand you one, or they'll, maybe a social worker will come by and say, here you go. So yeah, and those are fine. Those forms are perfectly fine. One problem, though, is if you fill it out in the hospital and then you hand it to them, which is fine, now you don't have it. So the hospital has it, but you don't have it. So if you do something like that and there's any way to keep a copy for yourself, that would be great, because you want your healthcare directive to help you wherever you end up. If you're at the doctor's, if you're in another hospital, if you're in another state, you don't want to be stuck without a healthcare directive. Thank you for that question, Geraldine. Okay, let's see. Okay, I'm looking for the questions. Maybe I'm just scrolling through and not seeing other questions. And it looks like we're just about out of time. I was hoping to keep this to a half hour, which I have done. So I'm gonna let you know if you had a question up there and I didn't see it, I didn't answer it, I'm really sorry. Please reach out to us. You can reach out to us on our website. You can call us 925-943-2740. Our website is absolutetrustcounsel.com. I'd love to be able to help you. We're here, we're working, we're getting things done, and we can help you too. Thank you so much for your time. I hope it was fun for you as it was for me. And stay safe. And now I am going to turn off the video, but I'll probably screw that up too. So there we go.